Good morning. I am Judge Leslie Kim Smith. We are now live streaming on YouTube and on the record. Calling case number 25001797NF, Anthony Bankston versus Michigan Automobile Insurance Placement Facility et al. Counsel, will you place your appearances on the record, starting in plaintiff's counsel?
Good morning, may it please this honorable court, Dion Webster Cox, P 70422, and I represent Anthony Bankston.
Okay, and for defendant, Michigan Automobile Insurance Placement Facility?
Good morning, Your Honor. Mark Naraki on behalf of the MAIPF and MACP.
All right, and for defendant, State Farm Mutual Automobile Insurance Company?
Morning, Your Honor. Karen Clark on behalf of defendant State Farm.
All right, and finally for Progressive?
Good morning, Your Honor. Nicholas Carroll, P 87718, appearing on behalf of defendant Progressive.
All right. May the record reflect, I had an opportunity to speak to counsel off record. There is a pending motion before the court that's scheduled for Friday, and that would be defendants Progressive Marathon Insurance Company's motion for adjournment of the scheduling order to move to track 3. After discussing the matter with the attorneys and there being no objections, the court is going to grant that motion. I'm going to move you to track 3. The witness list is going to be due February the 6th. Discovery cutoff is March 19th, and case evaluation month will move until May 2026. So the motion will be taken off the court's calendar. Also, the court is also going to waive late or cancellation fees for all parties. All right. Now, next, I have 2 motions. I have a defendant State Farm's motion for summary disposition, as well as a defendant Michigan Automobile Insurance Placement Facility's motion for summary disposition. After reviewing the motion as well as the responses, the court and replies, the court's going to go forward first with defendant State Farm motion for summary disposition. So, Ms. Clark, if you're ready to proceed, you may begin.
I'm Your Honor. Thank you. I know the court's read all the pleadings. I'm just going to give a little bit of an argument and a little bit of a fact refresher just for the purposes of the record. Mr. Bankston was in an Uber that was driven by a Mr. Mobo, and Savannah, I'm going to say McGahee, I'm not sure exactly how to pronounce her last name, is a potential resident relative of Mr. Bankston. And the reason why that's important is because there's some discussion regarding 2 distinct State Farm policies that are separate. So the first is regarding Mr. Mobo, who is the Uber driver. Mr. Bankston is not a resident relative, not a named insured, not related to Mr. Mobo in any way. It's undisputed by plaintiff that he does not qualify for benefits under Mobo's policy because that is his personal policy, but he was driving for Uber at the time of the accident. There is a brief argument by Progressive regarding the fact that 3114 subsection 2 should apply rather than 3114 subsection 1. However, just to sort of briefly raise and dismiss that issue, subsection 2 indicates that it only applies if there's no other policy of insurance. And there's clearly 2 other policies of insurance that we're discussing here, the State Farm policy regarding Savannah McGahee, as well as Progressive's policy. So it's our position that as to Mr. Mobo's policy, that doesn't apply. We move back to 3114 subsection 1. Bankston is not a resident relative named insured under that policy. So as to the analysis for our argument today, we move on to Savannah McGahee's policy, who is the potential resident relative for Mr. Bankston. So I'm going to start with PIP because there's 2 different provisions that are exclusions regarding PIP for coverage related to rideshare activity, like in this case. The first one is 6820P, and there's also a 6129AY. The language of 6820P is unambiguous and makes it very clear that there is no coverage for an insured, who would be Bankston in this case, under the resident relative policy, while operating or as a passenger in a motor vehicle other than your car, a newly acquired car, or a temporary substitute car, which is operated in the business of transporting passengers and is covered by the security as required by the No Fault Act. It's very clear that there is coverage with Progressive, and there is coverage and the necessary security required by the No Fault Act in this circumstance. So it is State Farm's position that this exclusion would allow for there to not be coverage under the State Farm policy for PIP for Mr. Bankston. I don't believe that there was any response or any argument that addresses that language. It appears that the majority of the argument is going to cover the 6129AY language. And this is for PIP as well as UM. I want to start with PIP only because the position regarding UM is not a priority position. It's more just that UM is entirely contractual, and it's our position that the contract excludes it, regardless of whether or not there's any coverage for uninsured or underinsured motorist benefits with Progressive. So starting with PIP, though, the language is similar. There's no coverage for an insured occupying a vehicle while it is made available or being used to carry persons for a charge. That's the exclusion. It says item A, or this provision, does not apply if it's the use of a private passenger car, if you or a resident relative are occupying a non-owned car as a passenger. And the analysis here is going to hinge on non-owned car. Non-owned car is not its most basic definition. We did file a supplemental Exhibit B, and I apologize for not having this original provision initially, but non-owned car means something specific under the State Farm policy. It means a car that is in the lawful possession of you or any resident relative, and that is not owned by you, any resident relative, any other person domiciled in your household, or an employer of any person described in 1, 2, 3 above. So this is a circumstance where this vehicle, Mr. Mobo's vehicle, was never in the possession of Bankston, lawfully or otherwise, but it was never in his possession. He was merely a passenger in this vehicle that Mr. Mobo was driving. So that means that that exclusion, or the exclusion to the exclusion, or the provision saying the exclusion is not allowed under certain circumstances, is not met. So what that means is that you go back up, the coverage, or the exclusion to the coverage does apply, meaning the exclusion under 6129AY does apply, and State Farm is properly excluded as far as those PIP benefits would go. As to the uninsured motorist provision, it's identical language. The difference in that argument, though, is that it's not State Farm's position that Progressive is somehow higher in priority for uninsured or underinsured benefits. UM benefits are entirely contractual. That same exclusion is also there for uninsured and underinsured motorist benefits. So State Farm's position as to that is merely just that there's no coverage under the contract for uninsured and underinsured motorist benefits in this scenario. So we are seeking summary disposition as to both claims for PIP and UM benefits. We are arguing, obviously, that Progressive is in the order of priority for no faults, but it's just a contractual argument as to the uninsured and underinsured motorist benefits. So we believe we're entitled to dismissal for both of those.
I've got a few questions. I didn't quite understand, when you look at the policy, for the PIP benefits, it indicates there's no coverage for an insured for damages arising out of the ownership, maintenance, or use of a vehicle while it is made available or being used to carry persons for a charge. But then it says that this exclusion does not apply to the use of a private passenger car. And then subsection D says if you or a resident relative occupying a non-owned vehicle as a passenger. So the plaintiff didn't own the vehicle that he was a passenger in. So why would this exclusion apply?
Because non-owned car is defined in a particular way, and State Farm's policy does have that bolded and italicized to show that it has a special definition pursuant to the terms of the policy. And that is under, it's attached as our supplemental Exhibit B. And what non-owned car means is a car that is in the lawful possession or lawful possession of you or any resident relative, and that is not owned by you, any resident relative, or any other person domiciled in your household, or an employer of any person described in 1, 2, 3, or above. So where that hinges on is the lawful possession language. And this vehicle was never in the possession of Anthony Bankston. He was only a passenger being driven by Mr. Mobo. Mr. Mobo obviously had possession of his vehicle under all of the circumstances involved in this accident. So without meeting that definition, that exclusion does apply.
Oh, I see what you're saying. Okay, well, let me also ask you another question is, how does State Farm have the authority to limit PIP benefits since it is mandated by statute? So are you basing it on MCL 500.3017?
That's correct, is that they may provide policy exclusions denying coverage when there's ride sharing platforms that are involved.
Right,
that is a proper exclusion. Go ahead.
But this statute in section 1 says an authorized insurer that issues an insurance policy insuring a personal vehicle may exclude all coverages afforded under the policy for any loss or injuries that occur while a transportation network company driver is logged in. But then if you go to the section 7, it says all as used in this section, all of the following terms mean those terms as defined by section 2 of the Limousine, Taxi, Cab, and Transportation Network Company Act. And it says personal vehicle. And if you look at MCL 257.2101, and it defines what a personal vehicle is. It says a personal vehicle means a motor vehicle with a seating capacity of 8 passengers or fewer, including the driver, that is used by a transportation network company driver that satisfies both the following. 1, the vehicle is owned, leased, or otherwise authorized for use by the transportation network company driver, and the vehicle is not a taxi, cab, limousine, or commercial vehicle. So it sounds to me that this definition is limiting 3017 to those vehicles that are transportation network drivers' vehicles, not everyone else's. Because your example, then if, let's say, a person decides that they want to get unlimited PIP benefits, then based on your analysis, that means if they then get into an Uber vehicle, they're only entitled to what the Uber insurer would provide, and that limits them from getting unlimited benefits that they would be entitled to under the policy.
I understand what the court is saying. I think that with regard to the court's analysis and some of the argument that we made in the reply brief discusses it, that says subsection 2 of 3107, it addresses it in a broader instance that says it does not require an automobile insurance policy to provide coverage while a transportation network company driver is engaged in providing a prearranged ride. In other words, there's no limitations that would restrict those exclusions to only an individual who's driving under those circumstances. So under the language of 3107 subsection 2 and in 3107 in general, I think that the language allows for broader exclusion that would allow for this instance, in this instance, for it to be properly excluded. And I think it does address, with the language, it does address other circumstances, but I do think that it is appropriately excluded and written to appropriately exclude under the way that the law is written as of right now. So that would be my response to that.
Do you have any Court of Appeals decisions that addresses this issue?
There's nothing specifically that I have as far as Court of Appeals. I do think some of this stuff is up on appeal, but I don't have anything, at least as of right now, between the way that this would go.
Okay, thank you. And I got a response from defendant MAIPF.
Yes, Your Honor, I know you reviewed everything. Obviously, you've looked into this very detailed with your analysis. I'll just break it down pretty quickly. One, as I stated in my response to State Farm's motion, any business exception that State Farm would have in their policy is a contractual agreement between the insured and State Farm. It doesn't apply to third parties. I cite a plethora of cases that deal with that. Do you want me to argue priority or just response to State Farm's brief?
Yeah, I didn't quite understand. One of the arguments you made was that contractual terms apply to the named insurer, but not to plaintiff. So that's your argument. I think you said that the plaintiff was an innocent third party to the contract.
Correct.
Okay, all right. Go ahead.
But regarding, just regarding priority, Your Honor, I mean, 3114 is pretty clear. You first go to the insurer of the vehicle involved, providing transportation. However, the last sentence of 3114.2 says, unless there's other applicable insurance.
Mhm.
There is, I know State Farm insured the vehicle. Let me back up. There's no dispute at the time of the accident. Nobody disagrees that Bankston was in a vehicle owned and operated by Moblo in the business of transporting people through Uber, and Uber's insured with Progressive. The vehicle he is in was insured with State Farm. He also lived with his grandmother who was insured with State Farm. With that said, 3114.1 sends you to subsection 2. However, subsection 2 doesn't apply if there's other insurance available, which would then send you back to subsection 1, which is resident relative insurance with State Farm through his grandmother's policy. Which I would say the order of priority would be first State Farm under 3114.2, because they insured the vehicle. Second, I would say State Farm under resident relative with grandma, and last Progressive as they insured the Uber. I mean, I rely on my brief for the most part, the MSD that I submitted in response to State Farm's MSD. But I don't think the business, I mean, there's a plethora of law out there. It's kind of seems like there's a dispute between 3107 and all the case law that says that business exceptions don't apply to third parties. 3107 says they can exclude coverage. However, that's between the named insured and State Farm, not an innocent third party. A contract can't override the statute priority and rearrange the legislative priority intent as set forth in 3114. But irregardless, I'm sorry, that's not a word. Regardless, if it's either State Farm or Progressive, they cannot come to the MAIPF. The MAIPF has to file this motion for the court to determine priority under 3172. And that's why we're all here today, so the court can determine which one's in highest priority. I just know it's not the MAIPF.
Okay, thank you. And I also received a response from Progressive.
Yes, Your Honor, thank you. Excuse me, not to regurgitate what councils have kind of stated thus far, but as this court is aware, there are two policies that have been alleged by plaintiff. The first being a personal policy issued to his grandmother where he qualifies as a resident relative. And then the second being to Mr. Mobo, the Uber driver himself. As a movement for summary disposition, State Farm is required to demonstrate that there is no genuine issue of a material fact. However, as Brother Counsel kind of alluded to in his oral arguments, the priority rules would indicate.
Just a minute. We lost someone.
We lost plaintiff's counsel.
Yep. I assume that she will log back in. I'm gonna go off record. All right, we're paused now. Oh, here she is. Ms. Webster Cox, you can unmute your microphone. We
Thank you.
paused as soon as we noticed you logged off.
Thank you. My battery died and it wasn't plugged in on this laptop. So thank you very much. Thank
That's
you.
okay. All right, we're gonna go back on the record. All right, we're back on the record, and Ms. Webster Cox was disconnected from us briefly. So, Mr. Carroll, go ahead.
Thank you, Your Honor. As Brother Counsel alluded to, as the plaintiff is a resident relative, MCL 500-31141 would be the applicable priority rule, establishing that policy as the highest in priority. However, as stated, MCL 500-31142 holds that a person who suffers accidental bodily injury while an operator or passenger of a motor vehicle operated in the business of transporting passengers shall receive PIP benefits through the insurer of the motor vehicle if coverage is not available under any other policy, essentially making it a safety net type of priority rule, where if, in this instance, if plaintiff's grandmother's policy was not applicable, then we would look to the policy issued to Mr. Mobo. In support of its motion, State Farm has supplied a copy of the policy issued to plaintiff's grandmother, but did not supply any information regarding the policy issued to Mr. Mobo. As such, it is yet to be determined if coverage is not available under Ms. McGahey's policy, therefore creating a question of fact as to whether or not Mr. Mobo's policy is also available to provide coverage. So on that ground, Progressive seeks that this court deny plaintiff's motion for summary disposition. There are additional points I would like to make as well. As it relates to the uninsured and underinsured benefits, councils have already alluded to the fact that these are contractual provisions. They are not guided by statute or anything related to. Progressive's policy is very clear. It explicitly rejects any UM coverage. And so as such, there is no coverage available under such policy. Again, there has not been a showing of any coverage that isn't available under either State Farm policy that has been alleged. So once again, State Farm has failed to show that there is not a material or a genuine dispute as to any material facts at issue. And then lastly, as it relates to the exclusions, Progressive kind of mirrors the sentiments displayed by the court, in that the language of the policy issued by State Farm, or the exclusions, I should say, don't totally obviate all coverage. So, for instance, State Farm posits that since plaintiff was a passenger in a vehicle operated in the business of transporting passengers, he is not entitled to any benefits whatsoever. State Farm attempts to allege a policy exclusion that obviates any entitlement to PIP and or UIM benefits. However, there are two glaring issues. First, as stated, State Farm has not presented any evidence in support of its motion that illustrates a lack of coverage under Mr. Mobo's policy, which, as discussed, would be the policy highest in order of priority if coverage under Ms. McGahey's policy was not available. Second, the State Farm policy issued to Ms. McGahey states there is no coverage for an insured for damages arising out of the ownership, maintenance, or use of a motor vehicle, or use of a vehicle, excuse me, while it is made available or being used to carry persons for a charge. However, that same policy states further that this exclusion does not apply to the use of a private car in which you, the named insured, or a resident relative are occupying a non-owned car as a passenger. I know there was some discussion about definitions that were applicable, but the language is simple, it's glaring. As this is a contractual provision that has been pointed out by the court, the language kind of defined. So plaintiff was indeed in an Uber as a passenger, which was operated in the business of transporting passengers, but he was also a resident relative of the named insured and a passenger in a non-owned car. Accordingly, the exclusions do not apply. And so In light of these points and the facts that State Farm has failed to demonstrate that there are no genuine issues of any material facts that are germane to this lawsuit, Progressive seeks a denial of State Farm's instant motion.
Okay. Can you tell me what your policy limit is on the Progressive? Is there a policy, is it 250,000?
Yes.
All right. Okay, Ms. Clark, you are the moving party on this motion, so is there anything else? You also indicated that the definition of non-owned, you sent it in a supplemental?
Supplemental Exhibit B that was filed approximately a week ago.
A week ago, okay.
Yeah. It's part of the original 9822B policy language, and that was actually something I was going to address with regard to
Could you
progressive.
just wait, I'm just
Go
trying to find it because I got your reply, but it wasn't attached to your reply.
No, it was a separate pleading. It had its own caption, supplemental B.
Oh, it was filed under miscellaneous. In the future, if you could just attach this to your reply, it would be easier for the court to locate it.
Perfect.
Okay,
I
I'm
apologize
sorry,
for that.
go ahead.
That's okay. The only thing, a couple things I was going to address first with regard to Progressive's arguments that summary disposition can't be granted without complete review of the MOBA policy. We obviously disagree with that. As a practical matter, we were also limited to a page number of exhibits. For the purposes of this motion, if the court wants separate briefing or pleadings as to MOBO's policy itself, we are more than happy to do that. However, I think that at least there's no argument here that MOBO's policy is somehow higher in priority than both Progressive and the resident relative policy. I think, in fact, it would be a distant third, if anything. But again, we can address that separately if we need to. But with regard to the innocent third party arguments, I think there's a couple things that are worth mentioning. The first is that I think I know under a lot of circumstances, as far as innocent third parties go for PIP and the contractual obligations, the Michigan Supreme Court has largely done away with that analysis in Titan, discussing innocent third parties in general. But more importantly, a lot of that third party and innocent third party analysis hinges on the harm that would occur to an innocent third party. But here, there is PIP coverage with Progressive in the instance that the court would rule that there's no PIP coverage under the policy under 3017 with State Farm. So I think that analysis would be more functional, or there would be an equity way, or there would be another discussion worth having if there were no other applicable no-fault policy here, but there is with Progressive. So that would be our position as to the innocent third-party arguments. And the last thing I'd just like to state for the record is that State Farm is of the position that the dispute is between State Farm and Progressive. There's no circumstance where we believe that Assigned Claims is somehow responsible for this. It's our position that State Farm is excluded, obviously under the terms and provisions of its contract, but that would make Progressive responsible. So we're not opposed to the remainder of the MAIPF's position on that.
You're jumping ahead. We haven't heard the MAIPS motion just yet, but would I be safe in assuming that Mr. Moby's policy terms would be identical to those that you provided in plaintiff's mother's, Miss McGee's policy? Or
yes, there are identical rideshare exclusions in Mr. Mobo's policy as well.
Okay, is that something that you can provide as an exhibit to the court within 7 days?
Yes.
All right, 7 days. I'm going to take this motion under advisement, so I'll expect that policy to be uploaded as an exhibit to your reply by February 4th, 2026. And then if anyone wants to have some additional briefing on that, I will allow it. You'll have until February 11th, 2026, in which to file any additional briefing. And then I'm going to have you come back, if you can pull out your calendars and let me know if you're available to return on February 17th, 2026 at 10:30 a.m. via Zoom for the court to render a decision on the motion.
Judge, I am supposed to be having a trial in front of Judge O'Brien in Oakland County Circuit Court.
Oh, is that actually going?
I don't know.
Okay.
It's just on my calendar.
I'm in Malaysia on the 17th.
What?
Yeah. It's my last trip with my daughter. She's a senior and it's her winter break.
Good
All right,
for you.
Well, tell me when you come back.
Okay, I come back on the 21st, 22nd. I think that's the
Okay,
first
let me-
work day.
All right. Can you check your calendars for March the 3rd, which is a Tuesday at 10:30?
Let's see.
That's good.
At
March 3rd
10:30,
is
yes,
good.
Your Honor, that works.
March 3rd
Works.
is good.
Good for everyone? All right. Ms. Clark, if you can renotice your motion for March the 3rd, 2026 at 10 a.m. via Zoom. All right. Mr. Naraki, we're moving on to your motion for summary disposition that I don't think I need to hear a whole lot of argument. I think everybody is kind of in agreement and the court just has to make a decision in terms of whether or not it's going to be State Farm or Progressive, but don't let me limit you if you make the record that you need to make.
Your Honor, I'll rest on my brief.
All right. Anyone else?
Just for the purposes of the record, I know that there's some discussion that State Farm is highest in priority. We obviously dispute that for all the reasons that we just discussed in our motion, but we are not of the position that the plaintiff somehow gets to the MAIPF because of that.
Okay. Mr.
And
Carroll,
Your Honor,
go ahead. I'm sorry.
I was just going to say I had responded to this motion, and that was when Progressive had been granted their summary, and that's when I was like, oh, I got to have some coverage somewhere, and that's where I was trying to argue. So I'm fine with them being let out.
Okay. Mr. Carroll?
Nothing further, Your Honor.
All right. The only issue I see is I've got two insurance companies that are contesting their priority. If the court finds that there's a question of fact, then MAIPF may end up staying in this case. But what I'd like to do is take the matter under advisement, have you come back for the March the 3rd at 10:30, and at that time I'll render a decision on both motions.
Okay, thank you.
All right. Anything else we need to discuss before we go off the record?
Just a housekeeping. I know we're coming back on March 3rd at 10:30 for State Farm's MSD. Do you just want one order where all parties return on that date? Do you want separate orders?
Probably one order.
Okay.
All
Okay.
right.
And then I'm sorry, one more housekeeping on my end. I know that the court wants a supplemental exhibit with the reply regarding Mr. Moba's policy filed by February 4th. What was the response briefing, if any, that was going to be occurred? What was the deadline for that?
That was February 11th.
Thank you, Your Honor.
You're welcome. All right. Anything else?
No, Judge.
No.
All right. Have a great day.
Thanks, Judge.
Thank you. You
Alright.
too.
Thank you, Your Honor.
Thank you.